when we're hearing by video argument. And I'm going to pronounce this, and I hope I don't butcher it too badly. Obasogie?
I believe Obasogie.
Obasogie, okay, versus Bath Manor. And each side will have 15 minutes to present their arguments, and they can reserve, the appellant can reserve up to 5 minutes. I would just caution you, this is not a case where this is really going to come into play, but I'm trying to do it every time I give instructions to the attorneys, because I don't want to forget on a case where it is in play. And that is if there's any victims or if there's any children, minors, we don't use their names. We either just refer to them as a child or by their initials. Also, I assume since you both have been speaking with us that you can hear okay. Is everybody able to hear?
Yes.
And the other panel members are able to hear?
Yes.
Okay, good. Now, when you're arguing, obviously you unmute yourself, but when you're not arguing, if you would just mute yourself so you don't have any background noise coming that way. Okay, if you're ready to proceed, we're ready to hear your arguments.
Thank you, Your Honors. May it please the court. My name is Brian Smith, and I'm appearing on behalf of the appellant Spencer Obasogie on behalf of the estate of Cynthia Obasogie. I'd like to reserve 5 minutes for rebuttal. Your Honors, this case has to do. There were two assignments of error in this case. One was one had to do with the motion for judgment on the pleadings that was filed by the defense in this case. The other had to do with denying a denial of the motion for leave to amend the complaint. Just for a little bit of background on this, this was a wrongful death action that was filed. It was filed on behalf of an estate. The trial court's rationale for granting the motion for judgment on the pleadings was that the original complaint was filed pro se by the administrator of the estate, who was Spencer Obasogie. The trial court claimed that it constituted the unauthorized practice of law because he did not have an attorney on the complaint originally. So he files the complaint. He then has Attorney Lax enter her appearance on the case, file a motion for leave to amend the complaint to add her as counsel of record. And that motion was ultimately denied, and the defense's motion for judgment on the pleadings was granted. Now,
But didn't the court find that it was the unauthorized practice of law because the complaint was filed on behalf of the estate and next of kin, and therefore he was representing others in addition to himself?
Well, Your Honor, there was some mention of that there was another beneficiary to the estate. The only beneficiaries of Cynthia Obasogie's estate were Spencer and his sister Chloe. Those were the only two beneficiaries, and we would submit that, that's not really directly relevant to whether the complaint was legally void, because the complaint as originally filed complied with the wrongful death statute. So it's really a distinction without a difference, because the statute only requires that the action be brought in the name of the personal representative, and that is what took place here. That it was brought in the name of the Spencer in his capacity as executor or administrator of the estate, and so in that way, it's actually pretty much an identical situation to Cushing versus Sheffield Lake, which is the earlier 9th District decision, where a plaintiff brought a complaint in the name of the nominal party and not on behalf of herself. So in that way, it's very similar. The way the trial court tried to distinguish this case from Cushing was by saying that because there was this other beneficiary out there, his sister, that somehow that somehow that made a difference as to whether the complaint was legally void. We would submit that.
Counsel, in Cushing, I think what we ruled was that it was harmless error because he was the only beneficiary anyway. Was that what you got out of it, or was there a different holding that you got out of it?
Well, no, I think that was the, well, I think in Cushing, the court did say that it was they did say that there was that distinction made. They could and they mentioned that the estate did not include other individuals, and that Mrs. Cushing and the personal representative are one and the same. So they're trying to. I think that was the conclusion, that they were trying to say that they were one and the same, and that made that allowed her to bring the complaint on behalf of the estate. The problem in this, we would submit though that it's really it really doesn't make a difference, is that distinction doesn't render the complaint filed in this case legally void, as long as it was brought in the name of the personal representative. So he's not bringing it. So he's bringing it technically on behalf of a single person, which is himself in his capacity as administrator of the estate.
And counsel, I'm going to give you the 5-minute warning. Do you want to save time, or did you want to continue on?
I'd like to reserve the remaining 5 minutes for rebuttal.
Sounds good. Thank you.
Thank you, Your Honors.
All right, Attorney Good.
Counsel, you're still muted.
Oh, thank you. I didn't notice
Sorry.
that.
Trying to appease. Thank you, Your Honors. May it please the court. My name is Andrew Good on behalf of the defendant, or the appellee, Bath Manor Special Care Center. I want to address a few things that appellant counsel has indicated. One, there's no dispute that this matter was filed on behalf of the estate. Two, there's no dispute that it was filed on behalf of the beneficiaries, which included not only Mr. Obasogie, but his sister, Chloe. And in terms of why we're here today, counsel had indicated correctly that there was two issues. One was whether the court erred in granting appellee's motion for judgment on the pleadings pursuant to Revised Code Section 470501, which is the unauthorized practice of law. The trial court found that Mr. Obasogie, by filing the complaint pro se on behalf of the estate, which included both of the beneficiaries, constituted the unauthorized practice of law pursuant to 470501, which rendered the complaint a legal nullity and thus the matter never being initiated. So thus, they then determined for the second issue that they were denying Mr. Obasogie's motion for leave, did not necessarily per se give a reason, but that's what I wanted to jump into first, is in terms of the motion for leave. First and foremost, the motion for leave, as argued in appellant's brief, relies heavily on Civil Rule 15. And Civil Rule 15, as I'm sure everybody is aware, allows for amendments, and specifically, as cited in appellant's case, allows for the amendment to relate back when you're substituting a party or making amending claims that relate back to the original filing. Well, here, there is neither of those. The amended complaint contained the exact same allegations and counts, and what has been is clearly indicated both in appellant's brief and in the filings, the trial court filings, is that it was merely masked as a notice of appearance of counsel. The intent of the motion for leave was not to change anything, was not to do anything, and it was merely to indicate that Susan Lax was entering an appearance on behalf of counsel of Mr. Obasogie, who had filed the complaint on behalf of the estate. And so, while the leave was denied in and of itself, it really wasn't a motion for leave. It was in effect, masked notice of appearance, which had already occurred by Ms. lacks filing a notice of appearance approximately 40 days before the motion for leave. In terms of the unauthorized practice of law, statute is clear in that no individual pro se may file a complaint on behalf of another, and that is commencing, conducting, or essentially furthering without counsel. And in this case, that's exactly what happened. Mr. Obasogie, and as the legally appointed administrator of the estate of Cynthia Obasogie, which included the beneficiaries of himself and Chloe, refiled the complaint on behalf of the estate pro se. At that point in time, he had committed the unauthorized practice of law, which rendered that complaint an entire nullity. Subsequent to that, and after—
Counsel, how do you distinguish Cushing? I mean, I understand that part of our rationale was the fact that it was we determined maybe like a harmless error because of the fact that there were no other beneficiaries. But before we even got into that, that to me, when I went back and reread it, sounded like it was more of, and by the way, it's also harmless error. So it seems like our holding may have been that it was an error to begin with, that the personal representative brought the suit, as a nominal party, and was pro se.
I think that the facts of Cushing in terms of applicability of this case are relevant in a sense. So Cushing obviously was filed by by a individual that was the only beneficiary of the estate. She filed it as the representative. And what this honorable court found is that Ms. Cushing did not attempt to represent a third party, such as another individual, corporation, or other different legal entity. And then and for that reason, she didn't engage in the unauthorized practice of law, and this dismissal was not warranted. This court also noted it is significant that Ms. Cushing is the only statutory beneficiary at issue in this case. And this honorable court went on to say such action must be brought in the name of the personal representative of the decedent for the exclusive benefit of the surviving spouse, the children, the parents of the decedent, and the other next of kin of the decedent. And purposes of 21-2502, which is the wrongful death statute, personal representative means either the executor or administrator of the estate of decedent's estate. And in this capacity, the personal representative represents the interest of the statutory next of kin, not merely his own interests. Well, the refiled complaint in this case was filed on behalf of the next of kin. It was filed on behalf of Mr. Obasogie, on behalf of the estate, when he was already the administrator of the estate. And really, that's exactly—
Anyway, counsel, I'm sorry to interrupt you again, but is there any way he could have filed a suit as just the administrator? Because, the statute talks about the suit being filed in the name of the personal representative.
And I appreciate that. I think the case law in Ohio is clear that if you are representing the estate of an individual, and in this instance, if he was not representing anybody else and he was not the administrator, right, similar to what Cushing was, or there was no other beneficiaries in the state, that is a separate set of facts that could allow for an individual pro se plaintiff that if they were to file it pro se and find it and they were the only beneficiary of the estate, and then they subsequently moved to amend that, that is one set of facts, a specific set of facts that gives leeway as a harmless error to that pro se plaintiff. However, that is different from herein, which the Cushing court noted, that if the plaintiff had represented another individual, or if there had been another individual in the estate, then it would have constituted the unauthorized practice of law. And that's exactly why that portion of the Cushing is applicable to this matter, and it's directly on point, because that's what happened here.
Counsel, the other question I have, because I know you have more to argue, but I have a question that when I was reading the briefs, this was granted as a motion for judgment on the pleadings.
Right.
It looks like the trial court was considering evidence outside the record, though.
Well,
In the complaint, I mean.
So, well, what happened was the refiled complaint was filed, and attached to my answer, I included exhibits pursuant to my affirmative defenses, which were the obviously the unauthorized practice of law pursuant to 470501. I attached the specific exhibits, and those exhibits were then attached as exhibits to my motion for judgment on the pleadings, which the trial court also indicated that you're allowed to, in certain circumstances, consider attached and enclosed with the pleadings, which is the exact reason why I did that.
But aren't you supposed to turn that into summary judgment, just like on the 12b-6?
Well, I think you can have it as a motion for summary judgment, but I think there is case law out there in Ohio that specifically indicates that you are allowed to, and the trial court's allowed to consider information that's attached and enclosed with the pleadings. So that is why those specific documents were attached to my affirmative defenses in order to further support those. And then
would that be like the pleadings, the attachments, would that be like an account though, and a contract, things like that? Not necessarily who's his relatives and, more factual things.
It was the probate court public record that was the application to appoint authority. It was also the certified approval of the settlement proceeds, which continued to identify both Mr. Obasogie and his sister Chloe as beneficiaries. It was the initial amended complaint filed in the first matter, which identified Mr. Obasogie that he was filing it as administrator of the estate, because the original filing that he had done was indicated on behalf, and then he subsequently got appointed, and then he amended his complaint to then identify himself as the administrator of the estate. And then subsequent to that, Bath Manor was dismissed pursuant to a motion to dismiss. And so in terms of that, I believe that the court was within its rights to review and consider the documents that were attached to my answer and enclosed as exhibits to my affirmative defenses. And even if the court were not to consider this, let's say they were not to even look at those, the refiled complaint in and of itself is valid enough to show that Mr. Obasogie was filing it on behalf of the next of kin. At that time, he had filed it. He knew he was the administrator of the estate, and he even agrees in the appellant brief that it was filed, and as counsel had indicated previously, it was filed on behalf of the estate, and that the estate, both beneficiaries were both Mr. Obasogie and Chloe Obasogie. So in terms of that, in terms of the unauthorized practice of law, it's very clear. Mr. Obasogie, as administrator, filed a complaint pro se on behalf of the estate, which included himself and Chloe Obasogie. He cannot do so pursuant to 470501, which thus renders the complaint a nullity and inaction. And then subsequent to that, in terms of the motion for leave to amend, counsel emphasized, and I know I hit on this before, Civil Rule 15, but again, the motion for leave was not to amend the complaint. It was simply to identify Susan Lax as counsel for the estate. And that's exactly what the trial court found in its order, in that it said a notice of appearance was filed by counsel for the estate, Susan Lax. The notice of appearance of counsel for the estate was filed by Susan Lax. So it wasn't any intent for Susan Lax to come in and substitute herself as the personal representative for the estate or a special administrator, as some of the cases that appellant has cited. It's completely different. And counsel for appellant Ms. Lax has never been appointed the personal representative of the estate. So the motion to amend really wasn't a motion to amend. It was a notice of appearance, and that's what it was masked as. It wasn't changing in substance. It wasn't relating back because there was no changes. All it was an attempt to argue that the notice of appearance of counsel thus cures the unauthorized practice of law when a pro se plaintiff files a complaint on behalf of an estate. And so, just touching on a few of the cases that plaintiff has support, Douglas Daniel Bros. This case identified the mere substitution of parties in a petition without any substantive changes. And it dealt specifically with standing and the terms of statute of limitations. It did not involve a pro se plaintiff filing anything on behalf of a state. It did not involve the unauthorized practice of law. So in my view, Daniels is completely inapplicable to this matter. That was the same thing for Keys v. Pennsylvania Railroad Company. The court affirmed that the administration was not the real party in interest, but allowed the substitution of the administratrix after. And notably, both of these cases, Douglas and Keys, the parties were represented by counsel when they filed the complaints. That's another big issue is all of the cases other than Cushing cited by appellant in this case, they all had counsel when they filed it. And it was merely, most of these were looking at the amendment of a party that filed on behalf or as an administrator when they weren't an administrator at that time. And the court allowed them to amend after that. I know I'm running close out of time, and for purposes of this matter, I'd like to point the court specifically to one of the cases I cited, which is it's a 2019 eighth district case, which is Bone versus Fairview Hospital. I believe the facts are nearly identical to this matter. The plaintiff in that, after filing pro se on behalf of the state, argued that it had meritorious defense and that he was only filing it on behalf of himself, and that the defects in unauthorized practice of law was cured by retaining representation, which the court disputed. And so with that, I believe I'm running out of time here shortly. I would allow the court to and refer my court to the appellee's brief for the remainder of my argument. But I believe, and I would request that the court affirm the trial court's decision to grant this motion for judgment of pleadings and the denial of.
Can't turn it off now. You're out of time, as you can tell.
Yep.
I was trying to be so discreet about it, and I can't even turn it off.
Thank you.
All right, but you were keeping your time very well. All right, Mr. Smith, you do have 5 more minutes.
Thank you, Your Honor. Just a couple of points. Ultimately, now getting back to one of the points you made, the court did consider facts outside of the record just by looking at the number of beneficiaries here, because really there's no way for them to even establish that there's someone other than Spencer Obasogie as a beneficiary of the estate just by looking at the complaint. And from looking at the complaint on its face, there's no way to distinguish the complaint that was filed in this case from the complaint that was filed in Cushing, where the beneficiary and the personal representative were one and the same. So there's really no way to distinguish those just by looking at the pleadings on their face. Now, the Ohio Supreme Court, and I believe we mentioned this in the brief, they have allowed parties to amend a complaint solely to correct defects related to the party bringing suit. There were a couple of cases on point there. I believe it was Douglas, and also I believe it's Keys or Keyes versus Pennsylvania Railroad, where the Ohio Supreme Court said it was permissible for parties to amend a complaint solely to correct defects in the identity of the party or the party in whose name the suit was being brought. So there is precedent for allowing that to happen. Now, as far as the
Excuse me, but those did not involve pro se filings, did they?
Well, Your Honor, I believe they did involve filing. Now there was actually I believe it was Douglas was actually fairly similar to this case, because they noted that where a widow institutes an action as administrative for the damages for wrongful death under the mistaken belief she'd been duly appointed and qualified as such, then discovers her error and amends her petition to show she was appointed administratrix after the expiration of the statute of limitation. The amended petition will relate back to the date of filing of the petition. and the action will be deemed commenced within the time limited by statute. So there is precedent for, under a similar circumstances for a person bringing a lawsuit on behalf of an estate, the complaint being the complaint requiring an amendment to be legally sufficient, and the court permitting that amendment to take place in order to correct that problem and relating it back to the original date of filing. So there is some pretty solid precedent on point allowing parties to do that. Ultimately, the issue, and I just also want to mention, Spencer Obasogie did not bring this on behalf of the next of kin. He filed it as the administrator of the estate, and I believe that's an important distinction to make here. He filed it in the name of the in the name of the administrator or personal representative of the estate, and that's pretty clear just from the face of the complaint. It states on behalf of the estate of Cynthia Obasogie, not on behalf of the beneficiaries of Cynthia Obasogie. So it is in that respect that shows that it does comply with the wrongful death statute because it was brought in the name of the personal representative. And really, ultimately, this relates to the remedy, because there's no set of facts here where the appellee is going to face a second lawsuit or a second action for the same alleged wrong. So ultimately, not allowing the plaintiff to amend this complaint, it prejudices plaintiff, but there's no prejudice to the defendant in this situation because it was a refiled action. It was a Rule 41 dismissal. He refiles it. There's no chance of facing a second lawsuit. There's no prejudice to the defendant in this particular case. And so therefore, the court should have allowed this amendment to take place in order to correct this defect. It's consistent with this court's earlier ruling in Cushing. It's consistent with the prior precedent from the Ohio Supreme Court allowing these types of amendments. And it's consistent with the civil rules as well, with respect to Civil Rule 15. And quite frankly, the trial court overreached here just by looking at this outside evidence instead of just looking at the face of the pleading. So with those facts taken into account, we would ask this court to reverse the decision of the Summit County Court of Common Pleas and remand this matter to the trial court. And I'd be happy to take any questions with any remaining time.
I am just so impressed with both of you today because literally you were finishing right at the exact second. I just learned how to turn off that dinging noise, twinkle, twinkle, little star or whatever it is before, but you were right on point. Okay, any other questions from the panel?
No, I just wanted to say, I'm sorry. Go ahead.
No, I did not have any questions.
Okay, sorry.
Oh, you're not allowed to ask questions, Mr. Good.
I was going to apologize. I was going to say it initially when I started. I forgot my jacket just for candor.
Oh.
So, it was something that was bothering me. So I just want to let you guys know that.
We appreciate that, but we've got the robe, so we can hide everything, you see. So.
Right.
Okay. Well, gentlemen, listen, thank you for your presentations to the court. We will take the matter under advisement and issue a written opinion that will be sent to both of you and your sides, and also will be on our own website.